Hi, you're listening to the Lawyer Society Legal Podcast for lawyers, practicing advocates, law students, and judicial exam aspirants.
Lawyers from the state of Andhra Pradesh, Tamil Nadu, Maharashtra and Karnataka must be aware of specific amendments made in the late 1980s and the early 1990s to the Hindu Succession Act in their respective states. In Andhra Pradesh, the amendment came into force from the year 1985. In Tamil Nadu, it came into force from the year 1989. In Maharashtra, it came into force from the year 1994, and in Karnataka from the year 1994. So all these four amendments inserted identical provisions to the Hindu Succession Act, which is 29A to 29C. Through this amendment, the four different states gave coparcenary rights to daughters born into Hindu joint families. When these states gave the daughters coparcenary rights, they also gave it based on two different conditions. The first condition was that the daughters shouldn't be married on the date of the act coming into force. The other was that the properties should not have been partitioned on the particular date when the act comes into force. So these two conditions were seen identically in all four states. For example, in the state of Tamil Nadu, the two conditions were that the daughters shouldn't be married prior to 25/3/1989, and the second condition was that the amendment will be applicable to only those properties which were not partitioned already on the 25th of March 1989. So these were the two conditions seen in all four states. And after that, we had the central amendment to the Hindu Succession Act coming into force in the year 2005. As per the central amendment, there is only one condition, and this condition is that the property shouldn't have been partitioned before 2012-2004. So as you can see, there is clearly a conflict between the state amendments and the central amendment. The central amendment pushes the cutoff date to 2012-2004, and it also lifts the condition placed by the four states with respect to the marriage of the daughters. So now, for instance, in the state of Tamil Nadu, if the daughters who were married on the 25th of March 1989 did not get coparcenary rights from the state amendment to the HSA, and the properties were not partitioned until the cutoff date provided in the 2005 amendment, then such daughters would be getting coparcenary rights from the 2005 amendment, because although they were married when the state amendment came into force. So this was confirmed by a division bench of the Madras High Court in the case of P. Hemamalini versus K. Palani in the year 2021. It was reported in 2021 6 MLJ 513, and I will leave the citations in the description box below along with equivalent citations. Let me also give some more examples for easy understanding. If suppose in the state of Tamil Nadu, if a daughter remained unmarried on 25/3/1989, she would have got coparcenary rights after the amendment came into force. If suppose such daughter had a sister who was married on that date, then such sister wouldn't have gotten any coparcenary rights by birth. And if the partition in such family took place between 25/3/1989 and 2012-2004, which is the cutoff date in the 2005 amendment, then the married sister, despite gaining interest because of the 2005 amendment, since the property was already partitioned, she would no longer be able to make a claim in the property. Now, if there was no partition between the two dates, which is 25/3/1989 and 2012-2004, then although the daughter was married on 25/3/1989, now after the 2005 amendment, she can make a claim in the property because she now has coparcenary rights. So this is the brief discussion with regards to the conflict between the four state amendments brought to the Hindu Succession Act and the central amendment brought in the year 2005. If you need more clarification in this regard, you can always read the particular citation I have referred in this episode. Thanks for listening. Do follow us on the Spotify app, and if you're interested to read more legal articles, you can subscribe to my digital law magazine, the details of which I have left below in the description box. You can contact me on WhatsApp for subscription related queries. My WhatsApp number is 98407 18196. Thank you.